My name is John Gentry. I'm a certified public accountant, and I'm a candidate for State Senate in District 18, and I was a First Recon Marine for 8 years. Representative Dunn, I would be grateful if you would ask me the questions about what happens to the victims. I don't have enough time to go through it with this presentation. This agency, the testimony that you just heard from the Board of Judicial Conduct, they are impotent. And they just said that they are impotent. When they said, oh, well, if the judge just resigns, there's nothing we can do. They are impotent. They can do nothing to provide judicial oversight or judicial accountability based on their own testimony. They should be abolished. This agency violates the Tennessee Constitution expressly and as implied, and it is a usurpation of legislative power by the judiciary. And I think some of you already regret that there is no check or balance of power over the judiciary. But let me assure you that the members that come after you are going to greatly regret a judiciary that has no check of one branch over the other. Thomas Jefferson, 1821, the dissolution of our government lies in the power of the judiciary, an irresponsible body working like gravity by night and by day, gaining a little today and a little tomorrow like a thief over the field of jurisdiction, and shall render powerless the checks of one branch over the other. And that is where we are today, a venal and oppressive government with no check of one branch over the other. And I implore you, if you could see the pain, the suicides, the substance abuse that come out from victims of judicial corruption, you would want to restore judicial accountability, I assure you, because it is hard to watch. It is painful for me, the people that come to me from across this state and across this country and tell me their stories. On July 22nd, 1822, I pulled this out of the Tennessee archives. Governor William Carroll, our third governor, addressed the joint houses, and he said a well-regulated and independent judiciary is so essential to the character of the state and to the peace and happiness of every citizen that it has a strong claim on your attention at all times. Your attention, the houses, not an agency comprised of judges and attorneys. Our judiciary is not legislated, and you just heard that this agency is impotent against them. And we have a problem with rampant, corrupt state court proceedings on a routine basis. It is easily proven. I have already submitted 700 pages of appendix and remonstrance proving this incontestable fact. And the right of due process is a natural, God-given human right. And to violate that right, I want you to know the costs. And President Trump said it very well. Human rights abuse and corruption undermine the values that form the essential foundation of a stable, secure, and functioning society, have devastating impact on individuals, weaken democratic institutions, degrade rule of law, perpetuate violent conflicts, and facilitate the activities of dangerous persons. That is the cost of judicial corruption, summarized by our president on December 21st, 2017. And I'm going to go back to William Carroll's address, and I would beg somebody to ask me what it means, the character of a state. I would like to explain that. It'll take me 2 or 3 minutes. When we look at what President Trump said, have devastating impact on individuals, that devastating impact by corrupt courts against the litigants, it destroys their lives emotionally and financially, as well as that of their children, affecting generations, degrade rule of law. Our state and federal constitutions are ignored by judges, subjecting people to the whims of corruption and not the rule of law. And it perpetuates violent conflicts. These are the conflicts that are all too common that you read about a family murder-suicide because the divorce is so contested that one party just can't take it and they kill their family and kill themselves. facilitate the activities of dangerous persons. These are the people that go out there and take up vigilante justice and go out and try to shoot judges and attorneys, is because they can't find any relief anywhere, and they are hopeless.
Mr. Gentry, your time's up. Let me turn to the members to see what questions that they would have. Members, what questions would you have? Chairman Dunn.
Thank you. And I'll ask the question, but I won't be very specific, in that the judge is found to be corrupt or there was something. Not that somebody suspected. The judge always rules in the woman's favor or the wife's or the husband's favor or whatever like that. So what happens if to the person who, if it turns out that the judge was taking bribes or was unduly influenced some way?
Thank you very much for that question, Representative Dunn. Judge Gay is correct. Judges have immunity. And that's why the House has the sole power of impeachment, Article 5, Section 1. Once they are impeached, that immunity is removed, and then they can be sued. But the power of impeachment has been usurped by the judiciary. It has been surrendered by these houses to the Tennessee Board of Judicial Conduct. And, you know, Judge Gay said that there's no mechanism. That is false. That is ignorance of our Tennessee Constitution. The process is a person writes a remonstrance, and a remonstrance is a formal written protest against government policy or government officials. They present that remonstrance to their district representative. That remonstrance is presented to the full body. Historically, it is resolved that the House refers that remonstrance to committee for discussion. In this case, it would be to the judiciary. The complainant, the judiciary committee may look at the remonstrance, may call in that complainant to discuss it further, and then the judiciary would resolve, like, let's try him for impeachment, or no, we don't find any basis. That is the mechanism established in our Tennessee Constitution, and I implore these houses to take back the power that was given to you in the Constitution and restore the right of remonstrance to the people. When talking about how do you sue the judge, Representative Dunn, we had an incredible problem with judicial corruption in the 1960s and the 1970s. And as a result of an attempt of that, United States Congress enacted 42 U.S.C. Section 1983 that any person that violates your rights under color of law, including judges, are subject to civil suit. But here's the trickery. Where do you sue judges? You sue them in court in front of another judge. And 100% of 1983 complaints against judges are dismissed by other judges in our federal courts. Proponents of that legislation in 1983, they noted that state courts were being used to harass and injure individuals, either because the state courts were powerless to stop the deprivations or were in league with those who are bent on abrogation of federally protected rights, including the right of due process. And that view was echoed by Senator Osborne. And he said, we are driven by existing facts to provide for the several states in the South what they have been unable to provide for themselves, i.e. the full and complete administration of justice in the courts. And Representative Perry concluded, sheriffs having eyes to see, see not. Judges having ears to hear, hear not. Witnesses conceal the truth, falsify it. Grand and petit juries act as if they might be accomplices. And all the apparatus and machinery of civil government, all the processes of justice skulk away as if government and justice were crimes and feared detection. This is not anything new.
Mr. Gentry, I wanted to say focused on Chairman Dunn's question and answering the question.
So,
Chairman Dunn?
So before those...
wait.
Oh, sorry.
Chairman Dunn, you're recognized. Okay. Members, any other questions that we do have? Okay. Please. Calfee, Representative Calfee.
Thank you, Mr. Chairman. I've been here in the legislature 8 years, and I believe you've come before this committee at least 8 times. And we've talked in my office one or more times. What would you suggest that this chamber do to correct these situations?
God bless you for that question, sir. We have to restore the right of remonstrance. In the 1800s, they had a grievances and propositions committee. We need to let the people know that when they complain against a judge, they do it through remonstrance to their representative. And as I discussed before, that remonstrance would be reviewed in the judiciary. And we need to start impeaching judges and send a clear message. Tennessee is the volunteer state. And let Tennessee lead the way, because this corruption of our judiciary is not a Tennessee problem. It is a problem across this country and across this world. And I implore the members to have the courage to abolish this agency and let Tennessee lead the way, that the judiciary has been proven incapable of self-government and self-oversight, and that the legislative houses are going to take back the power of impeachment. And under Article 6, Section 6, judges may be removed by concurrent vote of both houses. But the only way the members are going to know to impeach under Article 5, Section 1, or the only way they're going to know to remove under Article 6, Section 6, is if the members start receiving petitions of remonstrance from their citizens. When you look at Article 5, Section 5 is impeachment, and it defines impeachment. Impeachment is for crimes committed in office. Article 6, Section 6 is for misconduct. And I can guarantee you, if the members of these bodies listen to the people and the corruption that is going on with case steering tactics, with excluding evidence improperly, and all the little tricky things that judges do to case steer and decide the outcome not according to the facts, but according to their own pecuniary interests. When those facts are presented to these bodies, you will see the corruption. And when you start to impeach, it is going to send a clear message across this state and across this country that Tennessee is leading the way in judicial reform and restoring justice, which is the purpose of our government. Preamble to the United States Constitution: we the people, in order to form a perfect union and establish justice.
Mr. Gentry, we need to focus on answering the questions. You made 4 points on that. Were there other points that you were trying to make?
Well, I want to make a point about the purpose of our federal government is to establish justice. And William Carroll said
I understand that. The question, though, was what specifically did you want this body to do, was the question. You answered it in four different ways, 4 different points that you made. Were there any other points that you were trying to ask us to do?
Absolutely. In January of 2019, I filed a petition of remonstrance received and recorded in the journals of both houses. I'll be happy to provide that with you. I have a redress of grievances sought, and in that is a list of reforms that I want. I want drug tests for judges. I want live stream recorded court proceedings just like these houses in every courtroom. I want every litigant handed a piece of paper that says you have a right of due process, and here's what due process means. You have a right to be heard, you have a right to present argument, you have a right to present evidence orally, you have a right to confront adverse testimony face to face, and you have a right to a fair and impartial judge, and you have a right to a trial by jury in civil and criminal cases. And if any of those rights are violated, you have a right to petition for redress of grievance to your district representative. And that costs the state nothing. It's a piece of paper that you hand to every litigant, plaintiff, defendant, civil and criminal cases. It's a piece of paper. And if you don't want the people to know what their rights are, that means you want to be able to violate their rights. And there are some other reforms that I put in the remonstrance that I believe will restore justice to our courts, will restore accountability to judges, and will heal this entire republic by restoring justice to Tennessee courts first. Thank you for that question, sir.
Calfee, yes.
In brief, please, in brief, if somebody in my district felt like there'd been wrong activity by a judge concerning them, they would file a petition with me, and then I would present it to the full House.
So
And of course, I'm sure I don't believe you live in my district, so I don't know who you filed that petition with, but that's what would happen, and then I'd move it on and then see if any action going to be taken. In short, please.
Yes, sir. Thank you. So, our House Rules of Order, Rule 15, petitions and memorials. Before a petition shall be received and read at the table, a brief statement will be filed with the clerk. So, the process for this is in the House Rules of Order. You would ask that litigant to state the facts, state the argument of why it was wrong, and the specific redress. The redress is not, I want millions of dollars. The redress is, I want to be made whole. I want things made right. You file that petition with the clerk's office. The petition is read at the table, and then the House typically resolves to refer that to a specific committee for deliberation.
Thank you, sir. Thank you, Mr. Chairman.
Thank you. Any other questions? Chairman Roberts.
I don't have a question, but I do have a comment. You kind of broke it down in two things. You said, the right of remonstrance and impeaching judges, and I have a comment, which is really almost a suggestion. The right of remonstrance, as you've defined it, to me is narrow. I'm not saying this critically at all, but I think about the right of remonstrance. I think about this age-old dilemma of, am I being heard versus am I being listened to? And so, to me, the issue here isn't the form of the remonstrance. In other words, it's not the form of whether you stand in front of assembly, or you talk to a legislator one-on-one, or you send them a letter, or it's a phone call. The form of the remonstrance, to me, is not the critical aspect. The critical aspect is someone listening to what I'm saying? Are they contemplating it? Are they taking it to heart? Are they doing anything about it? So in the discussions and the testimony that you've given before, there's been a lot of emphasis on the right of remonstrance, but my suggestion is, and I agree with you on this, we don't impeach judges. And I don't know how many we would have to impeach before we got everybody's attention, but I suspect probably one would be a great start. And I do think that is a right that we have, and I think it's a right that we haven't utilized. When we did the reconstitution of this board, I was not too particularly excited about the way that it was done, and I still, no pun intended, still think the jury is out on whether, or not we're going to have the most effective outcome. Do I believe we're headed in the right direction? I do. I mean, I think we made progress, but you know what? We don't have a long enough timeline to know yet. I mean, I think the next 6 months are probably going to be, quite a bit of revelation. But my point is this. My suggestion is not so much of an emphasis on the remonstrance, because I think in today's day and age is very easy. It's just my personal opinion. I think it's very easy to communicate with a legislator. How you communicate with them can be, a challenge. The greater issue is you're being heard. Are you being heard? And if you are being heard, then I would think that we might see some progress in this direction. I don't want to impeach a judge just to impeach a judge, right? Okay. But my questions earlier, I'm convinced there are some outlier situations, and I don't think they're common at all, but I think there's some outlier situations. No, listen to what I'm saying. Where criminal activity has resulted that somebody would wind up in jail if it were, followed to the full course. And I question whether, sometimes I wonder how many times that's happened and we don't know about it, because we are dealing in a world, let's just be realistic, we're dealing in a world where a lot of people know each other. and that can influence things. And I've made this comment repeatedly. The bad actors are easy to identify. What's really, really hard is when someone's 90% good. And what I mean by that is we look at this fine, upstanding citizen who's a judge, and we see 90% of their activity, which is right, it's upstanding, it's according to the rule of law, but it's that 10%, when their nephew comes into the court, or their favorite attorney is there, or whatever. That's what that causes so much trouble, because here's this person with a public persona being being this fine, upstanding person, and nobody wants to believe that this other part exists. So my comment to wrap it up is this: I think that the crusade, if you will, to remind the legislators that they have the right to impeach, that they ought to use this right when justified instead of shying away from it, is a very worthy crusade. I think the idea of remonstrance and the form of what that looks like sometimes for a lot of legislators sort of turns into a discussion of semantics. And so that's my comment. I don't have a question there. I'll leave it up to the chair whether or not he wants to give you a chance to respond or whether we talk later. But that's just my suggestion.
Yeah, you can respond to that. Yes, sir.
Okay, thank you, Chairman. As far as the timeline, and that we don't have enough data to know whether the Board of Judicial Conduct is going to start disciplining judges. When you look at their annual report already, they dismiss 100% of complaints filed by non-legal professionals. They always ignore litigants, and if they are taking action now, it's because of the public scrutiny, largely, probably caused because of the work that I'm doing, and so they're going to behave for a little while. But unless that power is restored to the House, this is going to be a short-term effect, and they're going to be right back, just like Thomas Jefferson said. Little by little, they'll be right back to the corrupt court proceedings. You're right as far as the form, Senator Roberts. Mason's Manual, Section 148, I believe, subparagraph 4, says petitions come before the body through communications, emails, phone calls, and here's the process that would be so simple for the members: is when you get a litigant, and we all know litigants call you and say this judge is violating my rights, is call the judge and say knock it off. And not just judges, police officers, state officials. Call them up on behalf of your constituent and say, knock it off. If I hear back from this person again, then I'm going to look into it. And if I have to file a petition on behalf of this litigant, I will. So just knock it off and straighten it out. And I think that would solve 90% of the problems if members just took the time to pick up the phone and stand up for their constituents. Now, the last comment about, let's not impeach unless it's a crime. I have been through this myself, and I was a force recon Marine for 8 years. I've been in some of the worst environments on this entire planet, and it nearly destroyed me. I pulled myself up, and I learned how to fight. I learned the law. I learned the rules, and I've obviously learned the Constitution. I've been to the Supreme Court of the United States in 2 cases. Everybody can't fight like I can. And everybody can't pull themselves up like I can. But 18 U.S.C. Section 241 says that any person who conspires to injure or oppress a constitutionally protected right is subject to 10 years in prison and or fine. So when you have a judge who is biased, not collecting bribes, when you have a judge that's biased, that is a denial of due process, and that is a constitutional right violation, and it is a federal crime. And the United States Supreme Court has said regarding Section 241 that Congress was broad And that includes all rights, including the right of due process. So when you have a judge who's, all these judges look at this and they think it's funny. They don't care that they don't allow this person to present arguments. Just a really quick example of the stupid stuff I see.
Mr.
Okay.
I'm asking you if you're going to respond to what Chairman Roberts had said.
I just wanted to give him an example of what seems simple is a federal crime. And just that example is, I was watching a court case because the judge was very obviously corrupt to me, and so the judge said, he went to this litigant and he said, "Do you have anything else to say?" And the litigant said, "Yes, I do." And the judge says, "Okay, you have 5 minutes." It's like closing argument thing, and the litigant said, "Well, it'll take me at least 20 minutes." And the judge said, "Fine, sit down. You don't get any time. You don't even get the 5 minutes I offered you before." That is a denial of a right to be heard, and it hurts. When justice is denied to you and you can't present your arguments, it cuts you to the bone. It hurts so bad when you're denied, when you trust your government, and then your government bullies and harasses you like that. Now, everybody else might think that's pretty innocuous. He just said, sit down, you don't get any time. But it's a violation of a right of due process, and under 18 U.S.C. 241, it's a crime. And those crimes need to be punished by impeachment. And I think, if we even just reprimanded these guys and started doing that, they're going to stop. But with this Board of Judicial Conduct and the impotence that they have testified to, it's going to go on.
Okay, members, any other? All right, Mr. Gentry, thank you for your attendance and your testimony. With that, Chairman Lafferty. Oh, wait, Chairman Roberts.
Thank you. We need to go back into session, and
you're exactly right. So we're back in session. Thank you, Chairman.
Okay. Thank you. So I'd like to. Are you prepared to entertain a motion on this?
I am. Yes.
I'm going to preface my motion with this comment. I made the remark earlier when Chairman Bell, of course, I sit on the Judiciary Committee. I had long been in favor of a reconstitution of this board, and the idea that Chairman Bell had in working with the various stakeholders that we passed, I really wasn't in favor of. Per se, I wanted to see some additional changes. Nonetheless, it was the place that we started, and we I think had a very clear understanding, and I say we as in Chairman Bell and myself, that this was a starting point, and that we would see where this would go. When we do we have a sunset hearing, we make a motion to extend somebody. It's not just a matter of kind of giving them life. It also affects what the comptroller has to do, because if they're on a short window, the comptroller has to go back in and do a sunset audit. Now, if we extend somebody, there's not anything that prevents us from changing our mind later and offering legislation to reconstitute or eliminate, terminate, whatever the case might be. But I'm going to make a motion for a 4-year extension with this caveat, okay? The point of the 4-year extension is so the comptroller doesn't have to turn right around and go back in for another sunset audit, which is really not the issue that we're talking about here. We're talking about whether or not bad behavior is being identified within the judiciary, whether it's being adequately investigated, and whether or not anything's being done about it. So I want to, the caveat to this is I want to build into this motion a follow-up no later than 12/31/2021 by the board to report on their activities and give us a clear sense of what's happened in the meantime. Now, separate and apart from the motion, I want to point out to the members that Judiciary Committee members are getting a monthly report from the committee. And I want to make you aware of that, and I want to make you just that's not one of those emails that we need to miss. So alert your legislative assistant, make sure that gets printed out, put on your desk, and you take a look at it. The whole point of reconstituting this board in the first place was this very question of, was bad behavior being overlooked or missed or just whatever it was. I think we're off to a decent start. I want to see it continue to ramp up and continue to improve. And what I'm not doing with this motion is saying, I'm fine with it, let's just renew it for 4 more years. There's some other practical considerations that go into this. So I want to make it real clear that that's what my mindset is. Let's renew them so that we don't have to send the comptroller back in for another sunset audit, but let's have them back here in a year. But even more important than that, let's watch it every single month when this report comes out. Okay? So that's my motion, 4 years with follow-up no later than 12/31/2021.
So we have a motion? We have a second? All right. Any comments, questions?
Chairman. That was the most long-winded motion I've ever made, so I apologize for that, but I just want to make sure what the intent is. Okay, thank you.
Thank you. Take a roll call in the Senate.
Senator Bell. Senator Bowling.
Aye.
Votes aye. Senator Powers.
Aye.
Votes aye. Senator Kyle. Senator Roberts. Votes aye. Chairman Pody.
Aye.
Chairman, you have 4 ayes.
And the House will take a voice vote. All those in favor say aye.
Aye.
Opposed? Ayes have it. 4-year extension. However, they're going to come back by December 31st of next year with a report. Thank you.